Hello and good morning, everyone. Welcome to, or welcome back to, the second day of Absolutely Interdisciplinary here at the University of Toronto, hosted by the Schwartz Reisman Institute for Technology and Society. My name is Monique Critchlow, and I'm the Executive Director here at the SRI. Before we begin today, we just want to take a moment to acknowledge the land on which the University of Toronto operates. For thousands of years, Toronto has been the traditional land of the Huron-Wendat, the Seneca, and most recently, the Mississaugas of the Credit. These and other Indigenous peoples across Turtle Island developed complex and effective governance systems that incorporated values based on reciprocity, respect for human life, and the intelligence of the natural world. When Indigenous lands weren't ceded through good faith efforts, they were often stolen, and their governance systems were disrupted by colonialism and replaced with treaty arrangements. Today, this land is still home to many Indigenous peoples from across Turtle Island who are working to reclaim their rights to self-determination and self-governance. We need to protect and honor the history and people of these places, and we are grateful to have the opportunity to live and work on this land. Although we may all be joining from different places today, we encourage you to reflect on the history and relations of the land that you live and work on. Absolutely Interdisciplinary is SRI's annual academic conference that convenes leading thinkers from a rich variety of fields to engage in conversations that encourage innovation and inspire new insights. Through today's programming, we aim to come together and advance new ideas through conversations, community, and interdisciplinarity. Before we get started, I just have a few housekeeping notes. Please note that today's session is being recorded. The Zoom chat will be open throughout the day, and we encourage everyone to share their thoughts and pose questions in the Zoom chat. The sessions are just structured in a way that at the end of every session, there will be a Q&A portion. At that time, we'd encourage folks to turn on their cameras if they're comfortable doing so. To ask questions, feel free to raise your virtual hand or place the questions in the chat, and the moderator will have a chance to get to your question that way. And if you run into any technical issues, feel free to reach out to the SRI team. You will find us based on the SRI listed in the name field in our Zoom chats. So with that, I would like to invite Dr. David Lee to introduce our first session. David is a professor at the Edward S. Rogers Senior Department of Electrical and Computer Engineering here at the University of Toronto, and an expert in computer security. He's a pioneer in the field of trusted computing hardware. His seminal work has inspired the low-level technologies that secure mobile payments and fingerprint sensors in today's smartphones. His current research focuses on securing mobile and embedded devices, making computing systems more trustworthy, and bridging the divide between technology and policy. David, over to you.
Thank you, Monique. And it's my pleasure to introduce the speaker for today's first session, Anna Su. Anna is an associate professor at U of T's Faculty of Law, as well as a 2022-24 Schwartz Reisman Faculty Fellow. Her research focuses on the law and history of international human rights, comparative constitutional law, technology and international law, and law and religion. Today, Anna will be speaking about one of the challenges that digital technologies pose for society, and especially for governments, which is the recent phenomenon of digital constitutionalism, in which various norms, laws, regulations, and principles are now being articulated to balance powers in the digital realm. And the significance of international human rights law as a uniquely important tool, no matter what the future of digital governance looks like. Over to you, Anna.
Okay, thank you so much, David. Good morning, everyone, and thank you for having me here. I'm grateful for this opportunity to share some of my preliminary thoughts on the role of human rights in the future of digital governance. So the rise of information society and the ubiquity of digital technologies in our lives brings new imperatives and challenges for digital governance. Traditional institutions, processes, and even rights that were previously helpful in grappling with social transformations brought about by technology might not be adequate with respect to the variety of complex ethical and legal issues emerging from the development and use of these technologies, such as, for example, the emergence of big private technology corporations acting as private sovereigns. And if there's anything that the current ongoing pandemic has clearly shown us, it's how dependent we have become on these technologies and how these technologies impact both our offline and online lives. In the last decade alone, the rise of the so-called algorithmic society has provided new opportunities for the exercise of our rights and freedoms, but they also present unique challenges to our current legal arrangements. So one distinctive feature of the digital sphere is that it's not only subject to government regulation, but also, if not mostly, shaped by private power. As legal scholar Frank Pasquale wrote, if Google and Facebook can set standards to define the protection of rights and freedoms on a global scale based on business purposes, it's not surprising that they can exercise a form of power or functional sovereignty which can compete with, if not overcome, that of the public authority. So today I want to talk about digital constitutionalism. Many of us who are interested in the present and many possible futures of digital governance have started to think about questions such as what should our digital world look like? What do we want Web3 or other iterations of the web or even the metaverse to look like? What kinds of governance tools do we have at present? And are they up to the task of making sure that technology, particularly AI and other powerful computational systems that feed off data extracted from users in a million ways, benefit us, and that any risk of harm from the deployment of these technologies is minimized or avoided altogether. How do we hold both public and equally important private power accountable, and how do we set up institutions for this purpose? Attempting to answer these big questions that I just posed should energize us to revisit existing relationships between public and private law, for instance, between people and government, and between people and private corporations that often operate across different jurisdictions. So digital constitutionalism is one reaction, or to be more accurate, one set of responses that has emerged in the face of our new datafied and network reality. The premise behind this development is that we cannot treat the digital space as unregulated as it was before, or as most of it has been in recent years. The idea that technology has to be free from any kind of regulation in order not to stifle innovation cannot be countenanced any longer. The digital space is too important, and in this sense, the regulatory origins of the internet itself can provide crucial lessons. For the algorithmic present and future, what we need is a constitutional perspective in order to create the kind of online future that protects human rights, upholds equality, democracy, and the rule of law. Now, why is this important? It's important to understand digital constitutionalism, right? Because the first reason here is we want to avoid path dependence. It's important to know and understand how we got here in the first place. Our internet today is characterized mainly by so-called walled gardens that are controlled by centralized intermediaries that thrive upon surveillance capitalism and are immune from almost any liability, thanks in part to past visions of law and power, which have thus enabled new forms of capital and power accumulation. So whatever new visions or plans that we have to construct our new future, whatever we come up with, and in which I argue that digital constitutionalism should be a part of, we should be aware of this history and critical of our past errors. The second reason why to understand digital constitutionalism right is that it speaks of the creation of institutions and infrastructure that allows for a more inclusive and global kind of democratic governance for our interdependent online reality. So a lot of this exponential growth of technical and regulatory issues in internet governance has broadened and deepened the so-called technological governance gap. And it has led to an increase of voluntary and private rulemaking initiatives such as the Facebook Oversight Board, right? So digital governance, in my view, should not just be about governing particular parts, but coming up with a normative vision for the entire digital sphere. And over time, what we would want is a multi-layered transnational deliberation on how we develop and shape these norms that will apply globally. Moreover, Another reason is that our digital future is also subject to some kind of geopolitical competition between, say, China on the one hand and US/Europe on the other, especially in the so-called race to regulate AI, which is distinct from the race to develop AI-based technologies. At the moment, Europe has the most robust regulatory setup for new technologies, and it is its explicit intention to have that so-called Brussels effect when it promulgates the AI Act, which is currently still being considered as a template for global AI regulation. But if all the rules only come from the West without any input or participation from people beyond Europe and North America, even though most of them will be subject to these rules, then it will inevitably have certain structural biases built in. And therefore, in this case, I would argue that a constitutional rather than market-based or market-informed approaches should be able to help create the kinds of institutions and processes that will facilitate a more global conversation. The third reason to get or understand digital constitutionalism is that it's an opportunity to address the perceived limitations of traditional constitutionalism. Our digital reality has made even more manifest the shortcomings of our current understanding of law and how it's inadequate to address our most pressing needs. So digital technologies not only affect individual lives, but also shape our collective social systems. It's not, when we think about it, digital constitutionalism is not simply about coming up with more regulations, but also coming up with new questions, right? One frequent example here in this regard is the critique that perhaps when thinking about our online digital future, rights or the rights framework supposedly is inappropriate for thinking about how to regulate these kinds of systems, especially when it will have to be reinforced by a court. Otherwise, these rights are not going to be of much use. But rights frameworks, and here I will talk more about this in detail later, have already the advantage of being widely accepted, and it can also be interpreted in a non-individualistic and a more structural way that I think will still be important no matter how we construct that sort of future. Another example points to the failure of old school or traditional constitutionalism to address issues of distributive justice, given its overemphasis on civil and political rights. So how we decide to deal with data rights and data governance, for example, is as much an issue of economic well-being and distributive justice among nations, in as much as it is a fundamental right for individuals. So all of this is really just me trying to argue or suggesting that digital constitutionalism offers us an opportunity to revise our prevailing understanding of rights in a way that captures the reality of the online world. For instance, like how does the reality of the online gig economy influence or change how we understand the right to work as understood under international human rights law today? My argument is simply that we should take advantage of this chance to get rights right. So I've been talking about what digital constitutionalism for a while here, but what is it exactly? So there's no single definition at the moment, but there have been a few scholars who have sought to define it in a number of ways. And let me bring them up here for a bit. You have one definitions posits that it's a constellation of initiatives that seeks to articulate a set of political rights, governance norms on and limitations on the exercise of the power on the internet. Another is that it's a project to articulate a set of limits on private power with particular attention to virtual communities. And another one, the most recent one, simply says that it consists of articulating limits to the exercise of power in a network society. The common denominator in all of these definitions is the idea of limited powers and protection of fundamental rights. And these scholars are borrowing these concepts from the vast literature on old school traditional state-centered constitutionalism and adapting them onto the digital sphere. But that means that digital constitutionalism requires us to develop new ways of understanding justifying and limiting power in a complex system where the digital space is not really separate or external to politics or society, and that legitimacy and power offline is relevant to the construction and shaping of legitimacy and power online, and one that decenters the state. So the state is the only one that is the main source of power. Now, central to digital constitutionalism as a regulatory project is the idea of human rights. It is tried by now to observe that human rights impacts of the algorithmic society are profound, which explains the so-called race to regulate AI and to hold powerful corporations accountable. So threats to privacy, freedom of expression, non-discrimination are just some of the most prominent and by now well-documented concerns of this development. Equally concerning is the use of AI-based systems for social control measures and law enforcement, including but not limited to facial recognition systems, emotion or emotional AI, social scoring, and automated surveillance. Even in the realm of social rights, for instance, a 2019 UN report has warned that in order to address the erosion of the right to social protection and the impunity, to address the impunity of technology corporations in the emerging digital welfare state, a new approach to data and AI governance that privileges human autonomy over market considerations is urgently needed. Now, there's no question that international human rights and human rights law apply in varying levels with respect to these systems. Moreover, it's often a source of principles and values in self-regulatory approaches, such as the ethics codes adopted by technology companies themselves developing these systems. If you look at the official government national AI strategies, at the very least, they mention protection of fundamental rights as one of the goals of these strategies. In another report by the UN, high-level panel report on digital cooperation, it was recommended that there's an urgent need to examine how time-honored human rights frameworks and conventions, for instance, and the obligations that flow from those commitments relating to digital cooperation and technology, and how human rights can be meaningfully applied to ensure that no gaps in protection are caused by new and emerging technology. Now, despite all these apparent enthusiasm for human rights as a principal tool to regulate the creation and use of these algorithmic decision-making systems, there remains some skepticism as to whether this is the appropriate tool for given some of its limitations. So for example, it has been contended that a specialized or a hyper focus on rights, say the right to privacy or non-discrimination, which is often framed as an individual right, obscures or ignores the broader enabling conditions that makes the violation possible in the first place. In addition, in that same example involving the right to privacy, often framing it in such a way directs our attention to the inevitable question of enforcement. What happens in the case of a violation, and there are no courts to enforce that, to enforce or to remedy that violation, right? One scholar has even also suggested that there's a mismatch really between the harms that human rights try to address and the harms caused by AI-based systems, because among other things, the black box nature of such systems makes it impossible to observe at which point in time an individual harm occurs, as the harm can manifest itself later rather than immediately. So given these understandable questions and formidable challenges, what should be the role of human rights and rights in general in this digital constitutionalism project? And my argument here is that notwithstanding these and other similar concerns, rights and its protection in a variety of ways still and should occupy a central, if not cornerstone role in the present and future of digital governance. Using the language of human rights is important because first and foremost, it's an established language or vernacular that has already gained worldwide acceptance and legitimacy. We don't need to reinvent the whole wheel, so to speak. We already frame our claims and debates about law, politics, and global justice in this language, and there are already institutions for monitoring, oversight, and adjudication plus a body of authoritative rulings and statements that already help define and limit contentious terms such as fairness and non-discrimination. It does not mean that these institutions are not open to any kind of reevaluation or improvement, but it gives us a starting point that carries some type of global legitimacy. Moreover, absent any binding regulation at the national or regional level at the moment, as I mentioned, the European AI Act is still being debated, still being considered, the international human rights regime can fill this regulatory gap as a shared global framework to urge states and governments to fulfill their obligations. That being said, again, it does not mean that the present system need no revisions. If the protection of human rights is indeed at the center of the digital constitutionalism project, as I've stated earlier, then it gives us this unprecedented opportunity to do several things. And here I would just like to offer 3 suggestions on what we can do with rights. The first one is that we need to apply and broaden how we understand the current rights that we already have. Right? Digital constitutionalism is not new. When the term was first coined in a paper in 2015, it was a study of various proposals of an Internet Bill of Rights, which has been around since the early or mid 2000s, such that digital constitutionalism, the term itself, became equated with efforts to come up with some type of an Internet Bill of Rights. And my own view here is, of course, that digital constitution goes beyond an Internet Bill of Rights, but about establishing some type of like overarching legal system that filled with basic norms that ultimately get translated and processed at local levels. But setting that aside, the ultimate aim of this digital constitutionalism project is really to define a comprehensive set of rights, principles, and governance norms for the internet. As recently as 2016, for example, the UN Human Rights Council adopted a resolution that affirmed that people's rights offline must also be protected online. And so, like other UN documents, this suggests that the internet is a fundamental enabler of the human rights that we have and implies that the current understanding can be applied to the internet. So these proposed bills of rights have a mix of old and new rights that are appropriate for the digital environment. So the most recent one, for example, is the 2021 Portuguese Charter of Human Rights in the Digital Age, which has binding legal effect. And it includes the right to assembly, demonstration, association, participation in the digital environment. And these traditional rights are recognized alongside so-called newer rights, such as the right to be forgotten, right to net neutrality, and the right to protection against abusive geolocation. Most recently, the US government White House AI Task Force announced that it is also planning to develop a similar Bill of Rights that seems largely motivated by concerns about discriminatory algorithms with respect to health, employment, and law enforcement. Now, these are all welcome developments, but in addition to applying and implementing existing rights that have been translated for the digital environment, it is entirely possible to reinterpret them in a way that they go beyond their individualist orientation. For example, with respect to freedom of expression online, it has been written that a more structural understanding of international human rights law could place a greater emphasis on obliging or developing positive obligations on the states or the governments to respond to systematic accountability deficits that pervade the social media ecosystem. The most recent Digital Services Act in the EU reflect this structural understanding of the right to freedom of expression by requiring large online platforms to assess and mitigate systemic risks that they create and to carry out a risk reduction analysis, especially with respect to adverse effects on gender-based violence, for example, or adverse effects on fundamental rights. Moreover, with so much attention to the creation of digital charters or Bill of Rights, it's also, in my view, a very opportune moment to reintroduce the idea of duties or responsibilities alongside these rights. It's tried to say that every right must entail some corresponding duty or obligation, but this has somehow been rendered invisible or forgotten. And in the digital world, we have the opportunity to make both duties and rights coexist and complement each other. And I argue that this is not unprecedented. Because once upon a time, or 10 years ago, to be more accurate, Facebook took a very modest step towards acknowledging that our new network technologies deeply affect our lives in ways that are not always captured or best shaped by the typical template of consumer and seller. And the result of that effort by Facebook was the Facebook Statement on Revised Rights and Responsibilities. Alongside user rights, that statement obliged users not to engage in conduct that was deemed harmful in that space, such as users are not to engage in denial of service attacks, or bully or harass other users, or post hate speech or incite violence. We don't have this language of duties or obligations in our offline public discourse anymore, let alone online. And we can debate about, of course, we can debate about what the substance of these duties might have, but uh, digital constitutionalism as a regulatory project can feature both language of rights and duties, if only to emphasize the relationality or interconnectedness of this world. The second thing that we need to do about rights is that we also need new ones, right? And not just adapt the existing ones to the digital reality that we have. So it's not enough to translate existing rights, but at some point, the interpretation or the reinterpretation will really stretch the limits of the concept. And so we need to come up with new ones in order to match what technology gives us at this moment. Why do we need more new rights? One reason is that a tailored vocabulary, say recognition of the right not to be forgotten, right? So one reason is that once you have a very specific vocabulary for this, it conveys a much clearer standard of conduct and increases the legitimacy of claims using that language by stakeholders. A recently published paper on digital human rights argued that there are limits on how we can interpret existing rights to apply to the online world. The authors argue that there should be a category of rights that are necessary to protect the unique online needs and interests that are not fully or effectively covered by the application of traditional human rights to cyberspace. According to them, the emergence of a new vocabulary for digital human rights norms could encourage online users to develop a sense of entitlement for enjoying online rights and facilitate over time the creation of suitable and effective remedies for violations that have occurred. And to my mind, this presents a very strong and robust defense of a number of new distinctive rights that we have that have for a common denominator the lack of equivalent rights under existing laws. So although a number of Internet Bill of Rights and have already surfaced in the early 2010s, the new rights that are being articulated in the last 2 to 3 years have taken into account advances in data collection and proliferation of these AI-based systems, especially in the realm of law enforcement and judging, such as predictive policing and automated risk assessments. So one such right that is not really new, but still remains to be recognized is the right to internet access, which has since been being promoted and suggested at the level of the UN since 2011. This has been adopted in many national internet bills of rights, such as in Brazil, which was the first such bill protecting civil rights on the internet adopted in 2014. Another example of a proposed new right taking into account these recent advances is the right to be forgotten. Another one is the right not to be subject to an automated decision. So as of this moment, there are many other technological developments which could prove to be a challenge for the existing human rights regime. And a few examples here has to do with emotions AI or affective computing, which has been defined as using AI techniques to sense and interpret human emotional signals. Another one is voice recognition, right? If employment decisions are going to be based either on voice or emotions, then it would be very difficult to ascertain or to determine what existing right would be applicable in these kinds of situations, even though they are clearly an affront to human dignity. And so if we use the category of the right to privacy, is that really appropriate? Does that really capture all aspects of this violation? And so this very brief, enumeration of tale of this emergence of these new rights show it may be the case that as technological progress continues, the gulf between existing legal categories, including legal protections, and what the technology actually does widens such that we should create new ones appropriate to the task. The last one here that I wanted to mention, what can we do with rights, is that rights should not just be understood to be about courts and judicial enforcement, but they are considered to be touchstones in a landscape characterized by the values of equality, democracy, and the rule of law, right? It's about the broader context rather than what they can do in the abstract or as a discrete right. When we think of rights, we immediately associate it with courts. And I think that's also a preoccupation with respect to traditional constitutionalism. And the thinking goes that if there are no courts or royal court to be had, even in this case, as often said with respect to international human rights law, then the conclusion is that these are rights that are of very minimal use. Right? But as I had mentioned earlier, one importance of recognizing rights is that they convey a clear standard of conduct. A user right to data privacy conveys an entitlement to a particular way of how that private data is handled. It also increases the legitimacy of such claims. Then that entitlement can then be used in a number of ways. So the philosopher Seth Lazar recently argued that whenever an exercise of power is made, not only by a public authority, but more saliently by a private entity, it must abide by preset or established standards of procedural legitimacy, undertaken by proper authority, and based on a substantive justification. But in building the kinds of institutions that will do all of this, right, that will set the standards of legitimacy, establish the processes for the selection of the proper authority, and come up with the required justifications, then rights would play a very important role. For example, there can be a right to participation in rule or standard creation within platforms, very much like what Facebook did in 2009 when it came up with a site governance voting system. It promised to publish draft versions of various rules, let users submit responses, and then release new versions based on the feedback. Facebook users would then vote on the draft if more than 30% of all the active registered users actually participated, and then their decision would be binding. This experiment, short-lived at that, did not really last long because not a lot of people participated. But that kind of experiment at democratic governance online is something that can and should be attempted again in another form. And while we know that platforms are not like nation states, they do exercise a type of power that should be legitimized. And the digital sphere, again, offers many opportunities for new models of governance that should address this concern. Now, similar to the idea of rules and standards in law circles, rights perform a similar function when contained either in a binding regulation, like a statute, or that can be enforced as discrete individual rights, such as the EU AI Act, or as part of a more admittedly vague-sounding ethics code, or if they're just a vague-sounding protection of human rights or fundamental rights preference, often included in voluntary self-binding initiatives such as ethics codes or corporate AI statements. The inclusion of human rights or references to it in these kinds of codes address understandable concerns about the lack of clarity in terms of normative values and principles that constitute what are the relevant ethical standards to which these kinds of AI-based systems should adhere. And so human rights in this sense need not be enforced by courts or tribunals, but are nonetheless useful because they become touchstones of this broader landscape that is aimed at promoting these rights. They are necessary, for example, to make systemic risk assessments, right? And they're necessary, or they're essential to making algorithmic audits work. It also means that whether rights are contained either in a statute or a binding public regulation or contained in a corporate ethics code, it need not be an either or. Both of them can coexist and perform different functions. And at the end of the day, protecting human rights ex ante, before and ex post after the development of technology should be the ultimate concern in this digital ecosystem. Of course, all of this is easier said than done. It's not enough that we protect these rights and principles at the level of rules, at the socio-political level. What gets coded or baked into these systems matter as much. And in keeping with the interdisciplinary theme of this conference, it's certainly a formidable challenge to design and engineer particular values onto these technical systems. How do we know, for instance, that these AI-based systems have the technical feature to ensure that certain values or commitments, such as the right to an explanation or justification, are reflected in the operation of that system? Or how do we ensure that human rights risks are taken into account even before a system is built? For instance, one major challenge posed by AI-based systems like recommender systems, which some argue as distorting reality in order to channel user attention for the benefit of the corporation or the system owner, threatening individual autonomy and dignity, um, giving rise to the concern that of subverting or manipulating authentic preferences. So we have emerging bodies of work that are beginning to do this. For example, engineering technical work on privacy by design, explainable AI, what scholars have been calling as human rights by design or legal protection by design, although they have yet to address the whole gamut of challenges. So how do we even consider the possibility that maybe some of these systems should not be built in the first place? So rights, what I'm just saying in this part is that rights simply as part of ex ante considerations in different socio-political and technical settings does mostly become part of a forward-looking and structural approach rather than something that is only recognized in the event of a violation and in need of judicial resolution or enforcement. So some scholars, just to conclude, so some scholars recently argued that what is needed in the field of digital governance are ideas for new institutions and institutional relationships, and that we should not just rely on familiar mechanisms to apply to novel problems. Otherwise, we run the risk of creating a path dependency. And I completely subscribe to this view. We need to take advantage of the emancipatory potential of this new moment. I've presented here a very basic defense of the role of human rights and rights in general, and what a reinvented or robust vision of it can contribute to the project of digital constitutionalism insofar as digital governance is concerned. Technology may evolve to dizzying levels, but human needs and freedoms remain the same, right? Freedom of expression, thought, self-determination, right to education, right to health, among others. And creating a future that preserves all of these is not just a task for lawyers or philosophers or even engineers, but for everyone. So I think I'll end it at that. Thank you so much for listening. I look forward to your questions.
Thank you very much, Anna. So I'd like to encourage or draw the audience to ask questions. You can either raise your hand on Zoom or type into the chat box, and I will either read out your question or have you unmute and ask a question. So we have a question here from Jonathan Strait. Jonathan, do you want to unmute yours? Yes.
Yeah. Hi, Anna. Thanks so much. So as you were going through this, I kept thinking of the challenges of translating from normative and ideas and language about basic rights to mechanizations of those rights, because that's really what we're talking about. And this is something that humanity has never done before. We've never tried to encode freedom of expression into a machine, for example. So how do you think about problems like, what mechanistically does some sort of procedural fairness for speech in the platform regulated public sphere look like? Or what does an explanation look like? You know, if you say you want an explanation of why someone saw something on their feed, is that a human language description in very general terms? Is that a complete trace of the algorithm? Is that algorithm source code? Is that internal, like what is that even?
Right. No, that's a great question. That's like probably somebody else's life project, how to translate these rights into code. I mean, I guess one of the things that I was not able to mention in this talk is about, well, first of all, when we talk about basic values such as fairness, non-discrimination, due process, for instance, there's a variety of meanings, and I'm saying that already human rights law tries to circumscribe or limit the number of definitions that there can be, but still, we're still left with not just one definition, but still many, right? So maybe it's not infinity, but now we have only 50. But even so, how do we pick out which one of those 50 gets encoded? I think I don't really have a very satisfactory answer to this point. But I think this is where the idea of democratic regulation comes in, that for as long as we might not agree on what particular version of these terms eventually gets coded or baked into the system, but for as long as there has been enough deliberation ex ante before the system is actually built and ongoing, so throughout the life cycle of the system or the life of the product, then that would satisfy perhaps not everyone there, but that would satisfy the basic requirements of this has gone through the process of consultation, this has gone through the process of like ongoing evaluation and post deployment assessment, right? And so that's probably the process part of how these values or principles or rules or rights get operationalized in the actual operation of the system. This is going to address many of the concerns about what substance eventually gets encoded into it. But no, this is a great idea for a project, and I hope somebody's actually working on it.
Yeah, I just want to add from the engineering side, like trying to encode some of these very complex concepts, particularly if they're very contextual, is a huge challenge. So yeah, I'd certainly like to hear if people are working on this as well. We have another question here from Stephen Coyne. I hope I got that right. Please unmute yourself.
Great, thanks. So thanks for a really fascinating talk. I just want to make sure I'm understanding like what's distinctive about legal rights for you. So like you can imagine legal regulation maybe that doesn't occur through rights. So I guess I'm just trying to get clear, like maybe the best way of answering my question might be, could you just give an example of what legal regulation might look like without appealing to any rights?
Right. Okay. That is a good question. I guess in my since I'm my background is in both constitutional and international human rights, so most of the things that I keep in mind are the ones who are already complaining that there's too much rights, and so what kind of I guess the position of the critics that maybe we don't want to make rights the basis, or rights framework the basis of these kinds of systems, is that we don't want it to be we just don't want a translation or a complete transplanting what we have on offline into something online, right? So it can be right now, most of the systems that we have are like, one way that you can think about it is that like maybe a system that is not constitutional but administrative. So you can say that we have a policy of ensuring that we need to protect fairness, due process, but the focus of these is not necessarily that there would be any violation of individual rights, but that what is the outcome that we want, right? But this is not a very good answer, but yeah, I cannot come up with a very specific example right now, but that's a good point though. Maybe I will get back to you on that.
Actually, if I could add a follow-up on that question. So something that has come up for me in the cybersecurity spaces, there's been recent proposed legislation. So Bill 26, C26 are in Canada, and some in the EU. So around cybersecurity, this is more of a collectivist, I guess, national security, public safety argument. But where it's relevant, I think, to some of the things you've said in your talk is that it also seeks to restrict or govern the use of technologies. They're more about how to deploy technologies in a safe way, but there's also language in there that said that they can just ban certain technologies or technologies from certain vendors, certain apps, that kind of thing. does that relate or dovetail with the, I guess, the rights-based approach to regulating or controlling technology?
Right, great. Yeah, no, so that's definitely, yeah. And that's definitely part of this. So whatever happens at the national level, so I keep making references to the EU AI Act or the Digital Services Act, but there are several regulations and initiatives that are also happening at the national level. So Canada being one of them, and I would say that this is definitely part of this universe of the digital constitutionalism project, in the sense that now you have many of these initiatives, whether national, regional, or international, that are being undertaken. So it's all part of this. And I guess my very small point in this talk is that rights is going to play a very or the human rights regime is going to play a very an important part in this whole scheme. And but that does not mean that there's no space for other sort of initiatives. So different jurisdictions would have their own data rights legislation, for example, as well as cybersecurity protection. And so at some point, I would say that a lot of these initiatives are part of this digital constitutionalist moment, because we never even think about regulating any of these things before. But now that we're aware of what happens if we adopt some type of laissez-faire attitude towards these things, then now we see that there's an imperative to come up with these kinds of legislation.
For sure. Stephen, I still see your hand up. Is that from the question before, or you have another question? Okay, your hand went down. Are there any other questions from the audience? Give people a chance to ponder it. Well, I did have one other question for you, Anna, if I may. So I noticed from the beginning of your talk, there's a focus on the, there's a focus on the digital rights on the internet. Right. And I was wondering, like there are other, I guess, areas where information is being collected. So for example, one of the things is like smart devices in the home, or more Internet of Things, self-driving cars, smart buildings, smart cities. Would that be the same? Like would a lot of the work or thinking that has been gone into just internet rights extend into these other domains, or what are your thoughts on that?
Right. My understanding is that a lot of these have the social media ecosystem in mind, but I would argue that because this field of digital constitutionalism is pretty new, I would probably argue that many of the thinking behind this project is that it applies to the internet writ large, including internet of things, such as all these smart appliances, the internet itself, internet governance issues such as the domain name system that we have. And so all sorts of things come under this very big umbrella of digital constitutionalism. So a lot of them have to come together, and then we have to come up with some type of constitutional perspective on how do we regulate, how does this become a kind of an order, right? And what are the norms that permeate this order? And so those norms might come from the bottom. So again, this is at a very abstract and high level. At some point, all the rulemaking bodies and from the technical level as well, they will have to come up with their own versions of how do you translate these very high sounding, abstract sounding values into something very concrete and tailored to the context.
Right. Sounds about right. I do have a question from Jillian Hatfield now. Jillian, do you want to unmute yourself, or I can read the question? I'll just.
Oh, I can read.
Yeah, it's further up on the chat. I missed it before too. So.
Oh, okay.
Do you see it? So I'll just read it. Isn't part of the problem that rights, especially human rights, are fairly abstract, and require a lot of process to translate into concrete limits in concrete cases. I guess this was in relation to Jonathan's question. Yeah.
Right. No, that's I think this is also what I sort of mentioned earlier, that it's going to take a lot of top down and bottom up. It's a top down and bottom up process of what these norms are, and it will be up to the stakeholders to use however way they want, or however way they need these norms, right? And so if you're an engineer, then you try to come up with ways on how to bake this into the software. If you're a lawyer, then you try to come up with statutes, legislation. If you're a corporation, maybe it's something that that finds itself in the corporate ethics code. And so at some point there will be a convergence that, okay, everybody knows that you have the right to freedom of expression online, and precisely what that means, right? In a social media context, for instance. And so there's a platform specific version of these norms, and the idea is that maybe this is the moment where we start developing those norms. It's necessarily a very organic process, but I think I guess one of the imperatives or the motivations for this talk is that we're at the beginning of that constitutional moment, and we want to take advantage of it by saying, like, okay, we cannot proceed the way we did in the 1990s with the internet. Today we need to come up with some ground rules of what we want this digital space to be in, and it's not completely separate from what we expect. It's not completely separate from what we do offline. I think Julian has another question here.
Yeah,
about...
you make a follow-up. Yeah. So I'll just read, is there a risk that human rights framing will be harmful and that it will focus the public on unnuanced demands for things that are technologically infeasible? For example, the right to be forgotten was something that governments had no ability to enforce, and it had to be left to search engines. And so that's not really limiting power.
Right, I agree. Yes, this is a very good point. It's not, I mean, perhaps I would say I would just have a very charitable, view of things, in the sense that we're still at the moment where we're trying to figure it out. I mean, this right to forgotten, for instance, like Google, the government, it was ruled by a European court upheld this right, and it asked Google to come up with a court that decides these things, basically passed the buck to Google itself to decide which cases get to be, how do you implement this right to be forgotten. And I agree that maybe that one limitation is that maybe what we want is not technologically feasible at the moment, but maybe at a certain point in the future, it can be done. And I guess the idea is that for us that we should not just be stuck with the way that things are being done right now, and hopefully this gets us thinking about, imagine more different things, how things can be done in the future.
Yeah, it's very enlightening. I have a question from Aluwag Batomi. So he asks, should there be different ways of regarding private corporations versus systems used by the government? For example, Twitter algorithms versus algorithms used by US courts. I'm not sure if I caught all that. If you want to unmute and ask the question directly, please go ahead.
Right, no, this is at the moment, it should be there should be different ways of viewing them. So, but Twitter algorithms, so I'm not I mean, I don't have an answer at the moment, but I guess just thinking off the top of my head, there should be a difference in the way that, at least under our current traditional mode of thinking with respect to power exercised by government compared to private corporation, is that we do hold the government up to certain standards, the Constitution being the standard for that. But at the moment, we don't really know what to do. So it takes a lot. I mean, this is part of the whole interdisciplinary nature of this enterprise, meaning that political theorists have to come up with a whole justification, of how do we relate with government, with corporations acting as a state in this kind of society or this community. And as of the moment, we don't have the language, we don't have a way of thinking about these things yet. And so what we're trying to do is to adapt what we know of how we deal with government and translating that to how we deal with corporations, but maybe we need a new one, a new political theory of the digital world as it is. And I'm not familiar with any literature on that at the moment, but maybe that's something that, that political theorists should start thinking about.
Right. I have a comment from Renee Black. So she says, but there is a structural asymmetry of power between the top-down and bottom-up approach. How do you approach that?
I would say that at least in the digital space, I hope I'm understanding the question correctly, but I think in the digital space, a lot of the motivation, a lot of the advocacy for limitations of power with respect to the big online platforms, for instance, or the government, is really coming from the grassroots organizations, from the bottom up. And so there's this idea of digital constitutionalism is actually very much informed by a theory of constitutionalism called societal constitutionalism, which pertains to a very bottom-up organic way of how norms emanate from how people practice the practices and the values of the people who are from below, so to speak. And so I think, so for example, all these internet bills of rights, right? So the right to the internet, right to be forgotten. A lot of these are advocacies from people on the ground, and eventually, they find themselves before the government, before the UN, for example, and hopefully they get recognized as a right with everything that that is attached to it. But I would say that at the moment, a lot of these, all the clamor for limitations is really coming from the bottom. The EU, of course, is there with all of their regulatory initiatives, such as the AI Act, the DSA, but that one is partly motivated by market considerations, partly by geopolitical concerns, but there's also a lot of civil society groups that are closely monitoring what is going on with those pieces of legislation, and hopefully, that means there's a lot of input from the ground, and they end up, coming up with something that is beneficial for many.
Okay. So we're almost up on time, so I'm going to wrap up by paraphrasing, I think, one more question or comment from Stephen. Hopefully I get this right. So I think the question roughly is, should digital rights be similar to classic constitutional rights, in that digital rights maybe are more subject to change because they're tied to technologies? And so should there be some distinguishment, some way to distinguish those, or something that distinguish those as two types of rights, or are they really the same?
I would say that they're all the same. So one of the so when I talk about rights, and then I say like we should adopt a constitutional perspective, it means that it doesn't necessarily have to be in a Bill of Rights, like what we have in the Charter, Canadian Charter, or what we have in the U.S. Constitution. But it's similar in the sense that these are rights that are that can be. There is a fundamental essence to it that is not just that it has to be recognized by people in power, by the people like the authorities, for instance. And so, I mean, I think what I'm trying to get at is that, from my understanding from the questions also before, is there a difference between legal rights and constitutional rights? And what I'm saying here is that rights in my view, both of those are the same. It's just that here I'm using rights in the general sense because for me, it does not have to be necessarily enforced in the court. So for example, international human rights law. We think of that as a basic norm, right? Or as a base, and we recognize them as basic rights, even though we don't go to a world court to enforce them. But that is something that gets, that permeates down to the national domestic systems, and then eventually they get translated in some form in the national context, and then that gets enforced within that domestic regime. And so I guess the rights that I'm thinking about here are more like basic norms that are at the meta level. And so that's why you call them constitutional, because they are at the very foundation of what we want this digital society to look like. But I agree, there's a lot more clarification that is needed here, and I appreciate the questions. I'll definitely work on that for the next iteration of this presentation.
Thank you, and a great way to end the session. So let's all thank Anna again, and I'm going to hand it off to Monique to start the next session.